Okay, so let's talk briefly about the automatic stay. All right. So the automatic stay is what takes into effect once the bankruptcy petition has been accepted by the bankruptcy court. And this is a note to creditors that you have to cease all collection um, activities, cease all collection actions. All right. Um, the idea is that it gives the bankruptcy trustee time to marshal the assets, get a feel for the bankruptcy estate, and then determine what each creditor will receive. If creditors knowingly, there is that level of intent there, but if they knowingly violate the automatic stay, they're going to be liable for damages. So that's compensatory, attorney's fees, and in some cases, in egregious cases, also punitive damages. And you may recall from 2080, punitive damages are designed, they have very little to do with the debtor in this case. I was going to say the plaintiff, but in bankruptcy, it's usually debtor and creditor. So they have very little to do with the debtor and more to do with punishing the creditor. All right. There are some exceptions: child support, spousal support, things of that nature, proceedings incident to divorce, custody, SEC investigations, and some other state-issued statutory liens. All right, but that's the automatic stay. The bankruptcy trustee, we've talked about. Let's talk about some of their powers. We already know what the bankruptcy trustee's main goal is. Powers of the trustee. So avoidance. The trustee can cancel sales or transfers of property from the bankruptcy estate, and this would be prior to filing. It can be after as well, but it cannot. They can also go back prior to filing and cancel transfers for fraudulent purposes or preferential payments. So that was the example where if I have 10 creditors that owe $10,000 and I pay one in full, that's a preference. The trustee can go and recover that $10,000 from the creditor in which I paid. That goes back into the estate. Also, the trustee is said to stand in the shoes of the debtor. So the debtor also can articulate, or let me say it this way, the bankruptcy trustee can articulate any claim the debtor would have had to avoid paying that creditor. All right. So those are called avoidable rights. They can void existing creditor obligations due to, things that we talk about in other areas: breach, fraud, and those types of things. Bankruptcy estate does include communal or marital property. All right. Property transferred by voidable transfer, and then proceeds from the sale of bankruptcy estate property. All right. There are exemptions, however. There are certain things that debtor, just say the bankruptcy trustee cannot liquidate and sell, cannot take from the debtor. All right. And the first being some home equity, right? And there's a limit. And actually, well, I'll come back to that point. There is a limit to home equity. So what does that mean? Well, it means that if you have a home and you have more equity than the limit, the bankruptcy trustee can't take the home, but believe it or not, they can compel the debtor to incur new debt as a result of the bankruptcy process. So if, let's say the limit is, just for simplicity, is $150,000, and I think in Ohio it's pretty close to that. Oh, I think it's actually less than that. And I have a $300,000 home that I own free and clear with no mortgage. All right. Well, I can be forced to assume a $150,000 mortgage to pay other creditors. That's the way essentially that works. Motor vehicles up to a certain value, same process. So if I have a really expensive car, I can be forced to assume new debt with the proceeds of that debt going back into the bankruptcy estate. Necessary clothing and household goods. So obviously I'm going to have enough clothes to get dressed and go about my business in society, be it work or social functions. Jewelry up to a certain amount. Tools of the trade, which makes sense. If I am a mechanic and I have mechanics tools, I need those to earn money so that I don't end up in bankruptcy again. Those are exempt up to a certain point. Portion of unearned wages. And these are unpaid earned wages. I said unearned, but these are unpaid earned wages that I can keep a portion of those. The idea is I'm still going to need wages to buy the essentials, pay rent, buy food, insurance, and things of that nature. All right, pensions are exempt. Military pensions, federal pensions, welfare benefits typically are exempt. And if I have a personal injury settlement, that is typically exempt as well, which can lead to some inequitable results. If I have a $1 million personal injury settlement, under the federal law, I can't be compelled to use that to pay creditors. The idea is that settlement was to offset for loss, pain and suffering, or what have you. Now, these are the federal exemptions. State exemptions are typically very similar. They may vary in amount. Some states do allow one house no matter what the value or what the equity. And that's why you've seen the headlines, $8 million house protected in bankruptcy, right? That can happen in some states, not under the federal exemption. So let's talk a little bit about the interplay between the state and the federal exemptions. So bankruptcy law gives states the opportunity to articulate their own exemptions, and many states have. And it also gives states to preclude application of the federal exemptions. So in those states, you have to use the state exemptions. All right. In states where they've determined state exemptions but haven't gone as far to make them required, debtors actually have a choice, and they're going to go with the more favorable set. Typically, the state exemptions are more favorable. So there are some states where debtors have a choice of which exemptions I want to be applicable to my bankruptcy, right? Okay. The bankruptcy process. So after the filing of the petition and the automatic stay, there's a creditors meeting that the debtor must be present for. The creditors don't have to show up, but the debtor must be present for the creditors meeting. And it's kind of a, I don't want to say free-for-all, but the creditors have wide leeway to ask the debtor questions about why they haven't been paying their debts as they come due. Right, and they also have the opportunity to explore things on the asset listing, as to, when did you buy this, why, and those types of things. So it can be a very unnerving experience for debtors but they are legally compelled to show up and respond to those questions. After that meeting, creditors have to file proof of claim. This is documenting that they are actually entitled to the money which they claim to be owed in bankruptcy. All right. Failure to do this means creditors don't get paid. All right. After that, property is distributed. All right. And in the next slide, we'll talk about how that happens. After distribution, remaining claims are discharged, which means they go away. They're never going to be collected legally unless reaffirmed, are reorganized and put into a payment plan. All right. So here's a flowchart mapping what I just described, but I want to talk about the distribution of assets. So once the bankruptcy estate is formed, then the trustee first will allow for secured creditors to be paid either to the amount of their secured property, or they'll allow the secured creditor to take possession of that property from the bankruptcy estate if it hasn't been liquidated to cash at that point. So secured creditors get paid first. Then unsecured creditors. All right, and there's this hierarchy here. So the first being domestic support, which is a fancy way of saying child support and alimony, get paid first. So that's the highest level unsecured claim that exists. Administrative expenses, which is, you guessed it, the attorney's fees. All right, so the attorneys get paid next. And I say attorneys, it's primarily attorneys, but it could also be accountants or CPAs or whoever has provided a service incident to the bankruptcy petition. Ordinary business expenses, this is relevant when you're operating a business. This is the power bill and the insurance bill if the business is continuing on. Or even if the business has gone out of business, that's where those creditors fall in line. Employees, wages, salaries for the employees. All right, so they get paid next. And so generally you want people who have worked to be paid for their work. So that's why employees are here. Employee benefit plans, which would include retirement plans and things of that nature. Certain farmers and fishermen, which is kind of an ancillary topic that I'm not going to spend a lot of time on. Consumer deposits. If your bank goes bankrupt and is not FDIC insured, this is where you would get paid as an account holder. All right. Taxes and fines owed to municipalities, DUI claims, and then everybody else. So this is your Capital Ones and your MBNAs and your Bank of Americas. All the credit card issuers were here, which is why they had a vested interest in lobbying for BAPSA in 2005. All right. Now, generally speaking, money runs out somewhere along this process, because if it doesn't, why did you start the bankruptcy process anyway? But if for some reason, maybe there's some claims disallowed or some preferences that drastically change the bankruptcy estate and there's money left over, the debtor is entitled to that. All right, that very rarely happens, but if that happens, that's the way we deal with it. Generally speaking, somewhere going down this hierarchy, the money runs out, and if taxes are paid, everything above is paid, and you only get 80% of taxes paid. Well, that means that your credit card lenders are going to get stiffed in the process, and claims from DUI would also be discharged. That's how the process works.